and thank you for joining us for today's webinar. My name is Christine Belcade, and I'm a partner in Denton's Employment and Labor Practice Group. Before we get started, I have a few housekeeping notes. For the benefit of all participants, attendee lines have been muted. Should you have any questions that you would like to submit during the event, you may submit them through the question and answer space. If we cannot address your question during today's webinar, we will follow up after the program. Please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. Note, Denton's can only issue CLE credit for attendance during the live broadcast of the webinar. Participation on the live webinar must be on a computer or laptop device. Credit is not available for joining via mobile device. One other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen for the code word given during the program. When prompted, you will need to enter the code word into the Q&A section of the screen. If you don't have a license in these states, you can disregard this. So now we are starting with the first part of our webinar, Staying Above Board, Updates and Trends with the National Labor Relations Board. Next slide. Joining me today are Denton's partner, Andy Gruber, and Denton's associate, Mike Disatel, both in the employment and labor practice with me. Next slide. Today, this is a brief overview of our course and the agenda. First, Mike is going to provide an overview of the National Labor Relations Act, the National Labor Relations Board, organizing activity trends, the board's recent overturning of the TriCast standard, which relates to union organizing campaigns, and the potential impact of President-elect Trump's second term. Second, Andy is going to discuss the Starbucks Corporation versus McKinney decision, which addresses preliminary injunctions. Third, I am going to explain the George Washington University Hospital Board decision, which further defines bad faith bargaining. Fourth, Mike will cover the Cemex Construction Material Pacific Board decision, which addresses when employers are required to bargain with unions without a secret ballot election by the employees. Fifth, Andy is going to discuss the McLaren-Macomb Board decision, which implicates non-disparagement and confidentiality provisions in lots of different types of agreements, including settlement and severance agreements, even for non-union employers. And finally, I will discuss the Stericycle decision that changed the standard the board applies when analyzing employee handbook rules. Next slide, please. And I'm turning it over to Mike now.
Thank you, Kiki. I appreciate it. And thanks to everyone for joining us today. We really appreciate it. As Kiki mentioned, I'm going to first start with a brief overview of the NLRA, NLRB, and organizing activities and trends, including a couple of recent cases and issues that are front of mind for employers right now. Our understanding is that many folks on the call today either have experience, knowledge about the NLRA, NLRB in general, or potentially have had run-ins with them as well too. So we'll keep it brief, more of a flyover, but we're happy to answer any more specific questions about the procedure and protocols as we go. Next slide, please. So the National Labor Relations Act of 1935 is really the bedrock legal framework for labor law protections in the country. There are some other different labor statutes that apply to certain sectors, certain workers, but the NLRA is really the big standard that a lot of people need to focus on. It's changed very little since it's been passed in 1935, and really what it's done instead has been interpreted through the courts and through the NLRB and through various general counsel memos as well too. One of the keys to know about the NLRA is that it does apply to union and non-union settings for any non-supervisory employees. The NLRA also provides protections across many different business sectors. Even some of those are not traditionally unionized. What Kiki, Andy, and I have seen is that even some sectors that were normally not unionized or seeing union activity, such as nonprofits, are now seeing an uptick in that kind of involvement. One of the big provisions of the NLRA is Section 7. So you will hear Section 7 rights, Section 7 protected concerted activity. Section 7 itself generally guarantees employees the right to form, organize, assist a union, to bargain collectively over the terms and conditions, wages, and hours of their employment, or to refrain from that as well, too. It also protects against discriminating for or against union activity one way or the other. Again, it generally guarantees the right to engage in protected concerted activity. This has been defined as when two or more employees take action for their mutual aid or protection regarding the terms and conditions of their employment. It's also been defined by the board subsequently as one employee taking action on behalf of other employees, or one employee taking singular action but meant to induce group action by the employees. So there are some multiple permutations to consider in what is protected concerted activity, and various board decisions that focus on those as well too. So some of the examples of protected concerted activity that Kiki, Andy, and I often deal with are employees asking a manager about a raise, protesting allegedly unsafe working conditions. That's not necessarily an OSHA matter as well. It can be an NLRB matter as well too. Posting about union support on social media, that has become a very hot button issue. These are the kind of issues that we're seeing more and more in our practice. And finally, employers and labor organizations who violate those safeguards are potentially liable for what's called an unfair labor practice charge. This goes through a investigation process by the region where you're in. It can go to a complaint. It may go to eventual litigation before an ALJ, potentially before the board, and then potentially to a circuit court or the DC Circuit, or even the U.S. Supreme Court, to the extent it gets challenged and appealed up further. So the National Labor Relations Act itself also created the National Labor Relations Board. This is an independent federal agency. It's not tied to the DOL or any other government agency. It's a quasi-judicial body charged with overseeing labor protections under the NLRA, and they're assisted by a general counsel. Currently, the general counsel is Jennifer Abruzzo, who was appointed by President Biden. The board members themselves is a 5-member board. They're elected to 5-year terms, nominated by the president with Senate consent. And one member's term is basically meant to roll off from the board at each year. The general counsel herself is appointed to a 4-year term by the president, again with Senate consent. And the main function of the general counsel is she will not only prosecute cases before the board, but will take positions and interpretations seeking to create changes or alignment with the board in various labor considerations in the country. So the current composition of the board itself, we have 3 Democrat appointees, 1 Republican appointee, and 1 vacancy. And one of the Democrat appointees, Chair McFerrin, her appointment is actually going to be ending at the end of this year as well too. So we will soon have another vacancy on the board itself. Because of the political nature of these appointments and the board itself, we often refer to what's called the pendulum effect. So depending on the political administration in power, we will see very pro-employee standards or very pro-management standards. As you can imagine, under President Trump's first term, there were very pro-management standards that were often being instituted. Under President Biden's term, there have been very pro-employee standards as well, and that's been facilitated by General Counsel Abruzzo as we go forward. And most famously, General Counsel Abruzzo also issued a GC memo in 2021, where she identified over a dozen significant changes she wanted to make within the law and various standards that she wanted the board to adopt as their position as well too. And over the last 3 years, we have seen her really make good on those promises. There have been a lot of decisions, as Kiki and Andy and I will talk about, that overturned multiple decades of precedent and created more pro-employee standards as well too that employers need to be mindful of. Next slide, please. So journal organizing trends, petitions have been up over the last 3 years under President Biden's administration. Petitions from last year to this year are up 27%. And in those petitions, whether they are RC petitions or RM petitions, so either filed by the union or filed by the employer, unions have won those 79% of the time. And furthermore, we've seen in certain sectors, for example, retail and food service, that number is actually a little bit higher. So really, once you kind of get that petition, a lot of times it's very difficult for the employer to then create a counter strategy to communicate back with the employees and to win that vote. Sometimes your fate does feel like it's sealed. So you want to be mindful of that. Do training, train managers on basics of the NLRA, how to proceed if they get a demand from a union, what to do if there's a union canvasser around your property as well too. It's really beneficial to do that before you get the petition rather than after. Furthermore, unfair labor practice charges are up again this year. They're up 7% from the prior year. And since the beginning of President Biden's administration, they're up 50% overall. The big elephant in the room that we've seen over the past week is what will the impact of President Trump's victory in the presidential election mean for labor matters? This is going to affect board decisions, general counsel memos, and potentially who the general counsel is themselves. Our position generally has been that if it is a board decision, that is the current state of the law, and we'd recommend that employers follow that until it's been reversed by the next iteration of the board. However, for GC memos, giving a position or an interpretation of the act, there is less risk of not following those, or at least pushing back against those as well too, because based on what the general counsel advocates, and we may see a new general counsel very shortly once President Trump is installed. Furthermore, we also may see President Trump ask for Jennifer Abruzzo's resignation. This happened with President Biden and the former general counsel Peter Robb back in 2021. He did not let Peter Robb finish out his term. Instead, he asked for his resignation. It was then fired, and that was actually upheld as a legal matter. So we may actually see the similar thing happen in reverse here in January as well. There's been speculation about who that general counsel may be. It may be Peter Robb. He may also be nominated as a board member himself. But the general consensus is that it will be a pro-management general counsel at that point who will get to work and maybe potentially reversing standards more in favor of management at that point. But in the meantime, the board itself is actually still forge ahead and still continue with the pro-employee trend as long as it can. As Kiki mentioned, at the end of last week, the board reversed its TriCast precedent. That precedent dealt with what kind of communications employers can make during a union organizing campaign in the lead up to the election. The TriCast standard itself had been in place for almost 40 years and was being followed by unions and employers alike pretty faithfully. In the case itself, though, it involves Starbucks, not to be confused with the one Andy will be talking about very shortly. It involves Starbucks and a communication by the company saying that if a union is elected, we may not be able to work directly with you to resolve any issues or grievances that you have. The board found that that's unlawful because it could constitute a threat that it may take away something from the working relationship with management, or that employees would not be able to directly work with their managers and their supervisors to fix any issues or concerns that they may have in the workplace. The board recognized a very narrow limitation that an employer could create communications and have information like that only if they are fact-based and only if they convey the employer's belief about circumstances outside of their control. The burden would then be on the employer, and that potentially how this case shakes out could be either more difficult for employers to establish. The one thing in that case too is that the board decided that they're not going to apply it retroactively, so any pending cases before the board are not going to have this application of this decision. Instead, it's just going to be applied prospectively. Next slide, please. All right. For those participants in Kansas, New York, New Jersey, and Pennsylvania, we do have our code word for you. It is NLRB. So as mentioned at the beginning of the webinar, we want to take a brief moment to provide that CLE code word. Any folks from Kansas, New York, New Jersey, or Pennsylvania, please type in that code word NLRB into the Q&A chat feature. Please make sure you hit send so that registers. And again, that code word is NLRB. If anyone needs that code word at the end of the segment, we're happy to provide it. Again, it is NLRB. With that, I will turn it over to Andy.
Thanks, Mike. I appreciate that. Super secret code word, NLRB, as we talk about the NLRB and its actions. And Mike did a fantastic job, of course, giving a brief overview and setting up this current matter that I'd like to spend a few minutes of your time discussing. That is the Starbucks Corp v. McKinney matter. Now, this is a U.S. Supreme Court decision from June of this year that focused specifically upon the board's ability to seek a preliminary injunction while the board conducts its administrative proceeding to determine whether an employer committed an unfair labor practice. So to put a finer point on that, the Section 10J of the NLRA provides the board the opportunity to seek preliminary injunctive and equitable relief in a federal court while it proceeds with the internal NLRB administrative process of prosecuting an unfair labor practice. Specific to this matter, in the Starbucks case, and as we all know, Starbucks has been through a series of unionization and union campaign circumstances over the last several years. This one specifically dealt with a Starbucks location in Memphis, Tennessee, in which a series of employees who were then later known as the Memphis Seven began to conduct certain unionization plans, and then invited a local news crew into the Starbucks after hours on Martin Luther King Day to promote their unionization efforts. During this period of time where the local news crew was in, there was also off-duty Starbucks employees present in the location. And during this entire time, there were employees continuing to perform after hours activity with respect to reviewing the cash receipts, and apparently the safe was open at the time. All of this led Starbucks to conduct an investigation as to the specifics of what transpired. And Starbucks determined that the Memphis Seven, the 7 employees at issue, had violated company policy by allowing non-working individuals, whether that was the local news crew or the off-duty employees, into the location after hours while the safe was open and while cash receipts were being handled. And this, apparently against company policy, resulted in Starbucks terminating those employees. Ultimately, the board issued an unfair labor practice charge with respect to the termination, claiming that it was a violation of the employee's rights under the Act. While that administrative unfair labor practice charge was pending, the board then sought the Section 10J preliminary injunction looking to reinstate those Memphis Seven back to employment while the administrative ULP was in place. The district court, in reviewing that injunction, took the more lenient standard of reasonable cause and just and proper approach to the board's petition. Essentially, the more lenient approach traditionally provided the board almost a rubber stamp of injunctive relief in Section 10J petitions. That provided the board more true positioning and leverage on an employer facing a ULP by putting them through a preliminary injunction in which courts would have an extreme deference to the board's position, and thereby placing the employees back in employment, or in any other instance of equitable relief, granting that equitable relief, and again, placing leverage and control over the employer while the administrative process of the ULP was pending. Starbucks, arguing that that lenient standard was against congressional intent of Section 10J, appealed to the Sixth Circuit, and there was a split amongst the circuits as to exactly what standard should apply with respect to board 10J petitions. Should it be the more lenient standard the district court and a few other circuit courts have adopted, or should it be the more standardized review of any other type of preliminary injunctive proceeding, which, as some of you may know, deals on a 4-factor test of likely success on the merits, irreparable harm, balancing of the equities, and whether the public interest will be served with the issuance of the injunction. Those 4 standard factors are well entrenched in any other equitable relief, but did not necessarily apply in certain circuits to board 10J petitions. The Sixth Circuit ruled in favor of the board and continued with the more lenient standard. Ultimately, that was brought up to the U.S. Supreme Court, and in June of this year, the Supreme Court, in an 8-1 decision, ruled that the more lenient standard was not within the statutory interpretation of the statute and reinstated across all circuits now the standardized 4-factor test with respect to the issuance of injunctive relief. Now, this 8-1 decision was almost arguable a 9-0 decision. Justice Brown Jackson concurred in the remand of the matter back to the district court on the 4-factor test, but did issue a dissent arguing over Justice Thomas's majority opinion, in which he, some would say, addressed more directly the board's approach in seeking the more lenient standard for injunctive relief. Now that the matter is back at the district court, that's still pending to determine how the district court will review, but ultimately the Starbucks McKinney decision has been seen in a long line of the Supreme Court managing the standards by which the NLRB and other administrative agencies operate, whether that is internally within their own administrative process or with the courts, focusing back to what the Supreme Court feels is more of a correct statutory interpretation of an agency's power, and in this instance, the NLRB's approach and decision. Now, with that change, coupled with a few other Supreme Court decisions, as practitioners, we now look at potential 10J injunctions in a different light. Before, a 10J injunction would almost be an automatic. It would be an uphill battle to place yourself in a position, whether that in the case of the Starbucks matter, a reinstatement issue while ULP is pending, or a host of other issues that could occur within a campaign in which 10J can be seen as a hammer to our clients trying to fight the ULP, and then also have certain injunctive relief filed against you that would place you in a negative position. Now, with the standardized injunctive relief approach, in certain circuits, clients now have an opportunity to elongate essentially the any kind of preliminary injunctive process, or avoid it altogether, seek other avenues, whether that is some type of resolution or settlement through the NLRB process, or in fact just simply continue to position itself to fight whether the ULP or equitable relief being sought. And so the board, who ultimately had argued for the more lenient standard, back to the concept that anything less would provide a chilling effect upon an individual's Section 7 rights, we are starting to see the board shift, the court led by the Supreme Court shift away from that chilling effect argument that General Counsel Abruzzo has identified as one of her primary drivers in many of the different decisions and guidance that she has selected. So this chilling effect concept you'll hear repeated throughout today is also likely to be tempered over the next several years. And the McKinney matter, the Starbucks McKinney matter, clearly has rejected that argument in favor of a more lenient injunctive relief concept, and provides us as practitioners to our clients more avenues for defense, resolution, and the calculus in total being changed when a ULP of that magnitude is submitted against our clients. So again, another opportunity for management employers to deal with a ULP without facing injunctive relief. And again, the court continuing to shift for a more strict construction over the statute and limiting agencies' authority. So with that, I just went through my next slide entirely, so I think we can skip 2 slides ahead. To Kiki's review of the George Washington matter. So Kiki, go right ahead.
Okay, thanks, Andy. Next slide, please. So I'm going to talk about a decision that is relatively recent from May of 2024, George Washington University Hospital. So in this case, the board issued a decision reversing a 2021 decision the board previously vacated after former board member William Emanuel, who participated in the ruling, was found to have broken ethics rules by failing to recuse himself from the case. So in this decision, the board held that the hospital actually violated the National Labor Relations Act by unilaterally withdrawing its recognition of a union and refusing to bargain in good faith. So what happened was in November 2016, the hospital and the union, the SEIU, Service Employees International Union, began bargaining in advance of expiration of the collective bargaining agreement, which is typically what unions and employers do when they already have a contract. And this CBA covered approximately 150 service employees. The hospital took a hard bargaining line, refusing to concede on its proposals, which included a management rights clause that gave the hospital the power to change health benefits and discipline workers without cause, the addition of a no-strike provision, non-binding mediation in lieu of mandatory arbitration, and provisions that would have given the hospital the power to unilaterally set wages and end the union's right to dues checkoff. So these were just employer proposals, but they were very, very strong employer side proposals that left the power in the hands of the employer without having to necessarily bargain with the union before making these changes. In 2018, after 2 years of bargaining with little progress, the hospital received a decertification provision signed by 81 of 156 employees in the bargaining unit. So basically, the employer was told by 81 of 156 employees that they didn't want the union anymore. So the employer immediately withdrew recognition of the union and canceled all future bargaining sessions. Afterwards, the hospital implemented new wage rates and a new compensation structure. Next slide, please. So this is a case about bad faith bargaining. Bad faith bargaining is typically found to occur when a party acts with a purpose to frustrate the possibility of arriving at any collective bargaining agreement, and the board examines the totality of an employer's conduct to determine whether the employer has bargained in bad faith. The union can also be found to have bargained in bad faith, but in this case, it was all about whether the employer did. The NLRA does not compel either party to agree to a proposal or require the making of a concession, and historically, even adamant insistence on a bargaining position is not in and of itself a refusal to bargain in good faith. Rather, typically, throughout the course of NLRB precedent, a party has been entitled to stand firm on a position if it reasonably believes that the proposal is fair and proper, or that it has sufficient bargaining strength to force the other party to agree. However, in this case, the NLRB found that the employer did engage in bad faith bargaining just by proposing certain terms for the collective bargaining agreement and holding strong to that position. So it was just through the proposals that the NLRB found this was bad faith bargaining. And these main proposals were a no strike provision, the provision eliminating binding arbitration, and the expansive management rights clause. The board found that the employer's bargaining proposals taken as a whole would have left employees and the union with substantially fewer rights and less protection than provided by the law without a collective bargaining agreement. So it was this totality of the circumstances, overall whole, these proposals that the employer was, bargaining hard for. The board said, sorry, just making these proposals is bad faith bargaining, despite the fact that the employer engaged in no unlawful conduct away from the bargaining table. None of the employer's proposals were unlawful on their own. The employer made several concessions from its initial proposals in response to concerns expressed by the union. There was no evidence that the employer insisted on or even refused to bargain over any of its proposals, although it did take a hard line in pushing them through. And the union repeatedly refused to engage in back and forth bargaining. So despite all of that, NLRB said no bad faith bargaining. The board ordered the employer to bargain in good faith with the union, directed it to rescind the changes in the terms of conditions of employment that it had undertaken after the decertification petition. The employer also had to pay some money out to the employees, making them whole for any loss of earnings or other benefits suffered as a result of its unlawful unilateral implementation of changed terms and conditions of employment with interest. And the board ordered the employer to compensate employees for any other direct or foreseeable pecuniary harms incurred as a result of the unilateral changes. So that's also been a trend with the NLRB, is to order monetary penalties as well. And so we saw that in this case. Some practical implications of the decision on collective bargaining. So this is a decision that really only applies to employers that have a union that represents at least some of its employees. A lot of the other decisions apply to both union and non-unionized workforces. This one has to do with bargaining, when you're bargaining over a collective bargaining agreement. And it really shows the importance of staying abreast of, the current law, the current NLRB precedent, contacting counsel before making the bargaining proposals. There has been a trend within companies to do the negotiations on their own and to just have a labor relations specialist who may not be an attorney handle the negotiations. And I think this case really emphasizes the importance of having, skilled traditional labor counsel who's up to date on all of the decisions, because just making the proposals could get you in trouble. Next slide.
Thanks, Kiki. That was great. I'm going to turn now to Cemex Construction Material Pacific case. This one came out at the end of last year, so it's been around for about a year or so. But as we're seeing, there are more interpretations and more issues and nuances to it that have kind of fomented over the past year or so. Next slide, please. As background, the case itself deals with when employers are required to bargain with unions without a vote among the employees to decide whether or not they want to be represented. So basically, is there a potential for an end run around a secret manual ballot election that's traditionally within the auspices of the NLRA? Previously, there had always been a secret ballot election. Obviously, during COVID, there was more mail ballots. Now the board has pushed back for more of its preference of having in-person manual ballots itself. The board in this case overturns almost 70 years of precedent. It really kind of, what a lot of commentators have observed is it kind of takes away from the democratic institutions of the NLRA to allow employees to have informed decision, to make a vote for themselves, and to vote in their best interest for or against a union. Under the new standard, the board has established that once a demand from the union to the employer comes in, the employer must do one of two options. It must either recognize the union and bargain with it over the wages, terms, and conditions of employment and hours for the employees, or it can promptly file an RM petition. And the RM petition itself would either test the appropriateness of the unit, or contend that that there's not majority support for the union itself. And the board is subsequently, through GC memos as well too, defined promptly as within 2 calendar weeks. So that's really not a whole lot of time in some situations, especially if the demand goes to maybe a manager at the company and they don't actually elevate it to HR or to in-house counsel immediately. If they sit on it, there could be a problem and a potential liability for the employer. Previously, what the process kind of involved was when the employer received the demand to be recognized as represented by the union, the employer could then refuse that request. The burden would then be on the union to file an RC petition, and then there would be the secret ballot election, and that's kind of generally how it have been done for decades. This overturns that. The board also in Cemex said if the employer fails to take any of those steps, the union can file a ULP. If the union then establishes majority support during that proceeding, the union will automatically receive a bargaining order. No election is needed. In some respects, kind of like, go directly to jail, do not pass go, do not collect $200, and you immediately have a bargaining order. Further, the board went an additional step and said if an employer commits any ULPs, even a single ULP during that election period, the lead up to the election itself, that can be grounds for setting aside the election and issuing what's called the AGISL remedial bargaining order. Typically, what the remedy had been for the board in the past is that they would provide for a rerun election. Those bargaining orders are really only for extreme cases where there was numerous unfair labor practices that had occurred. This makes it much more easy for a union to now become the collective bargaining representative for employees under these standards of CEMEX. This is one that we think that this might be one of the initial priorities under the Trump administration's board to be overturned, because it would revert it back to the established precedent that was in place for over 70 years, and actually allow for more of a enfranchisement to the employees themselves to vote how they want, whether for the union or against the union. So this is one that we think may be teed up for reversal very early on in the Trump administration. And that was all I had on CEMEX. I believe I'll turn over to Andy.
Thanks, Mike. We can advance the slide. I'm going to talk a little bit about McLaren-Macomb, and thank you for that additional advancement. And as we go into McLaren, and Mike did a great job of doing a review of CEMEX. And Mike, just to kind of add in on this, I think when Mike and I are going to talk about McLaren and Stericycle in the next two sections here of today's discussion. And I think that starting with CEMEX is a good starting point, because it puts into context the expansions of ULP opportunities under McLaren and Stericycle and how that directly plays into CEMEX. Mike, I don't know if you had any other to add to that, because again, I always see, and as a practitioner, and I'm sure Mike and Kiki see this as well, CEMEX, McLaren, and Stericycle are kind of the three-headed monster that creates a much more complicating set of factors for employers, whether that's who are facing a potential union campaign, because McLaren and Stericycle, as we're going to talk about here briefly, are going to expand ULP opportunities, and CEMEX brings in the idea that that can have a direct effect circumventing the, as Mike pointed out, the democratic process for unionization. And Mike, I don't know if you had any other comments on that, just to add in as we kind of go into and build on this process of how the board has triangulated really a very difficult row for employers to flow through.
Yeah, maybe as a practice pointer, I think it's a really great way of thinking about it the way you are, Andy, is these are kind of a category of ULP opportunities. So these can be advanced by the union at various stages. What we've also sometimes seen is the union will wait until election occurs and then file a lot of these ULPs seeking to overturn that election if they get an unfavorable result. And so that is something to also be mindful of. Even if you can get to an election and you're in the minority of the cases where the employer wins, you may still face a ULP or objection to the conduct of the election from the union as well too, which will then have to be litigated and investigated as well.
And so, exactly, Mike. And so as we go through this conversation today with everyone, leading off with CEMEX and then going into the next two, I think it puts everything in perspective and in context, as I mentioned earlier, as we hear about this. And so our thought process is now looking at McLaren-Macomb, which was a board decision. Again, back to that comment that I made earlier with respect to the arguments the board proffered in Starbucks-McKinney, that the board in McLaren argued that non-disparagement or confidentiality provisions that are fairly broad-based have the possibility of, magic language, chilling Section 7 rights unless narrowly tailored. What does that essentially say? Well, for broad-based agreements in severance provisions in which non-disparagement or confidentiality context could be put in place, and without limiting factors, that employees signing those would be waiving their right to protected concerted activity, as Mike mentioned at the outset of the call today, or at the presentation today. So having signed those non-disparagement or confidentiality provisions would in fact chill their ability to engage in Section 7 rights. And even if the employee voluntarily agrees to those provisions in a severance or other document, that an employee by law can't necessarily waive those Section 7 rights. So the board created in McLaren an opportunity to jump off into one of General Counsel Abruzzo's directives that Mike mentioned at the outset of the presentation, and that is to create restrictions on contractual arrangements between employers and employees that the board contends would have a chilling effect on their protected concerted activity abilities. And so McLaren, while focusing in on non-disparagement and confidentiality provisions, has been expanded or attempted to be expanded through some aspirational, purposeful word there, memos by General Counsel Abruzzo, specifically in General Counsel, the memo 2305. General Counsel Abruzzo went on to expand some of the open-ended questions about the types of agreements and that McLaren addresses and to whom they would apply. And in that respect, the General Counsel memo suggested that the McLaren opinion would be retroactively applied to any non-disparagement or confidentiality provision that was overly broad. It could potentially apply to supervisors. And it could also be expanded to include non-disparagement and confidentiality provisions that were found in pre-employment offer letters. So again, expanding the scope of what McLaren said with respect to contractual arrangements that employer and employees enter into that could potentially chill Section 7 rights. Well, what type we've been mentioning, broad-based non-disparagement and confidentiality provisions that are not narrowly tailored. Well, the General Counsel did attempt to identify what narrowly tailored provisions could avoid a McLaren violation. Specifically, non-disparagement would fall into more of a defamation prohibition. So as we all know, defamation has a much higher standard and must be false, while non-disparagement is simply speaking bad about somebody. So cutting the line and identifying a appropriate non-disparagement provision as defamation is essentially negating the concept of non-disparagement and really changing it to a non-defamation, which is prohibited by most state law anyways. Confidentiality provisions that would be allowed are those that would only be narrowly identified to protect the scope of proprietary and confidential information that would be typically found in any other type of protection of trade secret or other proprietary and secret information that an employer may keep. So we put all this together and we find that the broad-based confidentiality provisions that would just simply say a employee is not able to, talk about the set and circumstances of their employment and potentially even the terms and conditions of the arrangement could be a violation. Any kind of broad-based non-disparagement that would prohibit an employee, even from a mutuality basis, from saying anything negative about an employer, could also run afoul of the McLaren directives. Now, both of those concepts have been attempted to be used in a series of courts trying to negate provisions on their own. So outside of the NLRB administrative process, certain plaintiffs have attempted to use the McLaren thought process to negate arbitration arrangements or other settlement agreements that they have entered into in front of the courts. And for the most part, our review has indicated that courts are unwilling to expand McLaren beyond the limited scope that the board has suggested, going even so far as to suggest that a severability clause, which is contained in most contracts, could be used to negate a offending non-disparagement or confidentiality provision, but keep the remainder of the contract, that is the release and any other non-offending provision in place. So what the general counsel has attempted to do in expanding McLaren has also found the outset some limiting purposes and applicability in the general courts. So to kind of round out this, the general counsel and the board has continued to try to expand the McLaren concept to include, by guidance, stay or pay provisions, those that would involve any type of payback of bonuses or the like that are not, again, narrowly tailored and legitimately purposed in violating the McLaren doctrine, so to speak. And just recently, Region 22 in planned companies, an opinion that found an arrangement between a janitorial service and its specific clients, prohibiting those clients from poaching the janitorial services employees, would also have restrictive and chilling effect upon employees' rights under the Act, and did say would be improper. And the expansion of that concept is yet to be seen. So I think McLaren is a good example of a circumstance in which it creates a complete shift of mindset with respect to the types of circumstances a ULP could be filed upon. It again looks at neutral circumstances that the board identifies as having a chilling effect on an employee's rights, and also really highlights the, again, aspirational approach of the Abruzzo NLRB on the types of agreements and arrangements that she has found would be in violation of the Act. How that adjusts and changes is going to be an interesting point, because McLaren is and remains board precedent until it is potentially overturned by a reconstituted board under this next administration. So again, all the talking point and action point here is, as I'm sure most of us have done, is take a hard look at your severance arrangements and other agreements that are in place, particularly for non-management level employees, to make certain that they don't run afoul of the McLaren requirements. Next slide, please. And Mike is going to pick up the last piece with respect to the Stericycle expansion of ULPs.
I'm actually going to handle this one.
I'm sorry, Kiki is. I've lost track of the
problem. I'd
calendar.
love to hear from Mike more too. And just to piggyback on what you were talking about, Andy, with McLaren and Macomb, I don't know about you, but when I am drafting settlement and severance agreements for any employer now, I mentioned to them this issue regarding confidentiality and non-disparagement, and really it's what I've seen with my clients is it's been a business decision whether or not they conform the language to McLaren Macomb, which is much more restrictive in terms of what they can require the employee to agree to. But I think it's also important to note that that only applies to non-statutory supervisors under the NLRA. So that wouldn't apply to someone who, under the National Labor Relations Act, is deemed a supervisor, which is a expansive and complicated test, but basically it's a high-level manager who acts with independent judgment to make decisions regarding employees. So there's that analysis too, but it is interesting how the reach of the NLRB, went much further during the Biden administration, and we'll definitely be on the lookout for decisions coming down the pike once the composition of the board has changed again. Mike, did you want to?
Yeah, one other thing I just want to add is, the NLRB's approach in McLaren Macomb dovetailed and kind of aligned with other federal agencies as well too. Certainly, we're aware of the FTC's non-compete ban that has since been enjoined, but there are other agencies involved too, like the DOJ, who view this more from an antitrust perspective and a restraint on trade perspective. So it's also good to be mindful of those other agency approaches and how there might be overlap between that and the board decisions and standards.
Yeah, absolutely. And that actually brings up something else before I get to Stericycle is, that overturning of the TriCast decision regarding employer speech during the union organizing campaign. There also recently have been a number of states that have enacted laws that ban captive audience meetings, where the employer mandates that employees attend meetings on work time and they're paid during those meetings, but they have to sit there and listen to the employer talk about how terrible unions are and the reason why the employees should vote no against the unions. And so Hawaii, California, there's several other states that have enacted these laws. And so, it's important to have labor counsel who's informing you of the intersection between NLRB precedent and, other laws and decisions that are coming down. But moving
Yeah,
on to Stericycle.
I was just going to add, and I won't
Yeah.
take up any more of your time. I think you had a great point, Kiki, when you said the McLaren decisions with respect to refining contracts are truly a business decision. And I think it highlights what you also just said, which is counseling with labor counsel and reviewing those risks are incredibly important. And I would even add to dovetail or to segue into your Stericycle revisions, I think fall in that same category. So very interested to hear what you have to say about Stericycle, but kind of keeping that in mind that this is a business decision and one that needs to be well counseled to avoid the risk, as we've just pointed out, with what could happen in a worst case scenario.
Absolutely. Yes. Thank you for that. So we've got about 8 minutes left, and this is the last case we're going to discuss, and we do want to open it up to questions in case anyone has questions. So I will try to glide through this as quickly as possible without twisting up my tongue, speaking too quickly. So this is an August 2023 decision, which was a strong swing back in favor of employees, where the NLRB adopted a new legal framework for analyzing employer handbook rules. Stericycle is the largest medical waste disposal company in the US. They had distributed a revised employee handbook, and they had a number of employees unionized with the Teamsters Union. So they issued this revised handbook. It had new policies in it, and revised policies, including ones restricting use of personal electronic devices to break times only, prohibiting personal inappropriate conduct and behavior that maliciously or intentionally harms the company's reputation, requiring employees to maintain confidentiality of harassment complaints and during investigations, and prohibiting employees within the context of a conflict of interest policy to engage in an activity that adversely reflects the integrity of the company or its management. So the Teamsters Union saw the issuance of this handbook and filed unfair labor practice charges. The General Counsel issued a complaint under the theory that the rules unlawfully infringed upon these employees' Section 7 rights, which have already been addressed by both Andy and Mike today. The board in Stericycle, it was a huge decision coming down. They overruled the 2017 decision in Boeing Company, which back in 2017 was very shocking. And so now there's a new standard under Stericycle when evaluating a facially neutral work rule. So a rule when on its face doesn't seem like it's restricting anything or illegal. They're going to assess, the NLRB will assess whether the rule has a reasonable tendency to chill employees from exercising their Section 7 rights. And the key here is that the board is going to, and has been, interpreting the rule from the perspective of the employee who is economically dependent on the employer and who contemplates engaging in protected activity. And contrary to prior decisions, the employer's intent in maintaining the rule is immaterial. The employer can rebut the presumption only by providing that the rule advances a legitimate and substantial business interest and that the employer is unable to advance the interest with a more narrowly tailored rule. So the NLRB is really looking to the employer to say, This is my legitimate business justification for the rule, and board, there is no other way for me to say it. So it's, you know, a very high threshold for the employer to meet. Next slide, please. So after Stericycle, after this decision came out, you know, there was a lot of blog discussion over this and what's going to happen. And, you know, the recommendation has been and continues to be for employers to get their employee handbooks reviewed regularly by, you know, employment and labor counsel, because as we all know, the handbooks implicate lots of different employment laws as well as the National Labor Relations Act. And there are certain policies that tend to be quite broad when written by the employer and that may be found to be unlawful under Stericycle. And so those include policies regarding personal conduct, non-disparagement, conflicts of interest, mandatory confidentiality during investigations, no outside employment, no audio and video recordings at work, blanket restrictions on speaking to the media, and social media policies. Now, this standard may very well change with a new board composition appointed, you know, under the Trump administration. So we'll certainly will be on the lookout for that. But as of now, the Stericycle decision does apply. And just wanted to highlight a couple practical implications. There was a NLRB Division of Advice memo, which found that basically a no outside employment policy, an anti-moonlighting provision that required the employee to devote her full time to the conduct of the business and shall not directly or indirectly engage in any activity competitive with or adverse to the corporation's business or welfare, was unlawful, saying that under Stericycle, an employee who is economically dependent on their employer and contemplates engaging in protected activity could reasonably read this to think that this is preventing them from acting as a union salt, which is where an employee goes and gets another job and uses that position in the company to start a union organizing campaign. So this NLRB Division of Advice memo said that provision about not anti-moonlighting was unlawful under Stericycle. And then there was a recent Hawaii Pacific Health and Straub Medical Center decision that found that the employer's dress code policy prohibiting logo clothing other than that authorized by the employer and the union, other than authorized by the employer and union insignia was unlawful under Stericycle, even though there is an exception for healthcare employers that they can prohibit certain types of pins and, you know, other items worn on the clothing that could be dangerous in immediate patient care settings. But in this case, the board said, or an administrative law judge said, that this policy was way too broad and didn't come under that healthcare exception. So those are just a couple of examples of Stericycle in play. And again, this standard may again change. Next slide. Okay, we have talked a lot. There's so much more to talk about. We'd love to hear from any of you. If anyone has a quick question right now, we'd love to hear it. Okay, I'm not seeing any messages or hearing anything, but our contact information was on one of the initial slides. And I know that, you know, Andy, Mike, and myself, we'd be very happy to answer any questions that any of you may have by email or giving us a phone call. Thank you for letting us present today.
Thank you so much. Thanks, Kiki. Thanks, Mike.
Thanks all.
Well, thank you very much, Kiki, Andrew, and Michael for that presentation. I believe that brings us to our next presentation, which is Cannabis and hemp legalization, regulation, and its implications in 2024 and moving into the new year as well. So let me just say it's an interesting segue from what we just heard to now. And I'll say this, that the cannabis business affects every business in the United States, whether you're doing business directly in the industry, indirectly with the industry, which we see more and more, or you have employees, you will be affected by the cannabis industry. So let's go to the next slide, please. Joining me today will be Kelly Fair, and I will let Kelly introduce herself, but she is a fantastic cannabis law attorney and is viewed as one of the leading cannabis law attorneys in the country. And I'm Eric Berlin. I, along with Kelly, am in the Denton's Cannabis Sector Group, and we spend 100% of our time for clients in or impacted by the cannabis and hemp industries. And later in this session, Charlie Bachtel will join us. He is the CEO, founder, and president of Cresco Labs. Next slide, please. So our agenda for today, we'll discuss and give you just the update on the legal status of cannabis and hemp in the United States. We'll then address what are the issues that are preventing legalization, in addition to just the pure politics. What's so complicated about this? We'll then move on to possible federal reform for cannabis and for hemp, because they are viewed separately, as Kelly will discuss next. And then we'll look at the various legal implications for all the other businesses. I mentioned labor and employment, and there are a host of others. And we welcome your questions, and we'll answer them at the end. Next slide, please. So let me hand it to Kelly. And Kelly, I know there's a lot of confusion in the country between cannabis and marijuana. And could you just help us understand that a little bit better, please?
Sure. And Eric and I agree that this is a good table set for people that are just now thinking about the issue and really do need to just at a level set understand. And also for experts like us who work through these issues every day to be reminded, like, what's the difference, you know, as we go from plant to products. Scientifically, and my sister who's a scientist would cringe at this table set, but hemp and marijuana are the same plant. We're starting with cannabis sativa L. Hemp and marijuana, they express themselves differently in their THC profile, and that is the first place to start when we're distinguishing hemp versus marijuana and like what that means legally. So I'll start with hemp, which is the cannabis sativa L that's expressing itself as less than 0.3% of THC on a dry weight basis in the field. And there's some debate and some controversy about when do you test for that THC level in the field? Is it right at harvest? Is it somewhere prior? And then that impacts products, which we'll get to. But for our purposes in the field, less than 3% THC, 0.3% THC, your hemp. And with that, that expression of cannabis sativa L, you have a federally legal commodity now under the Farm Bill by virtue of the 2018 Farm Bill. And that means that hemp in the field and hemp derived products at this point have all of the benefits of being a federally legal commodity. So right out of the gate, we had the benefit of regulation of the crop in the field by the USDA to give regulations around testing and guardrails there. We had the banking regulators come out very early days to say hemp companies and hemp farmers can bank with no problems. They can have insurance, crop insurance with no problems. Where the hemp regulations have fallen short is the FDA stepping in to regulate the final products, which the FDA has exclusive jurisdiction. Hemp also gets the benefit of access to capital markets, which Eric's very familiar with. And so that is as I think about it, the federally legal cousin of cannabis sativa L. On the other side of the slide is marijuana. Marijuana is still scheduled on Schedule 1 under the Controlled Substances Act. This is going to be cannabis sativa L expressing a greater than 0.3% THC. And to be clear, you can have hemp growing in a field that turns into marijuana by going hot, as we call it, and becomes now federally illegal. And with that federally illegal, outside of a very narrow DEA controlled supply chain, any cultivation, distribution of marijuana is going to be illicit trafficking. And with that comes all of the benefits of being federally illegal, which is no access to capital markets, no access to banking, and insurance largely, though, you know, Eric and I both experience more and more ancillary companies coming on to support cannabis businesses. But a lot of use of cannabis, but not the benefit of that federal legality, which means no federal regulation of this expression of the plant, either in the field or in final products. But as I'll get to later in the presentation, as the final product regulation of hemp is starting to crystallize and get legislated on, that probably will then later translate over into final product regulation of the marijuana products at some point in the future. So with that, I'll hand it back to Eric. I think next slide. Oh, you're on mute, Eric.
Thank you, Kelly. Thank you for that as well. And if you listen to what Kelly said and thought to yourself, that's just bizarre. Like, why are they divided that way? What do those cannabis and hemp lawyers know that we don't know? Nothing. It really is that strange that we've taken the same plant and set a boundary. To be clear, that boundary of 0.3% delta 9 THC by dry weight is man-made. It's not based on nature or biology or science. And so Kelly and I and the other lawyers with whom we work, we spend all our time navigating, and it's just become more difficult to navigate these areas because there's overlap and contradiction. And so I will say I've never gone wherever I've been in the country to go visit a dispensary, gone to a dispensary without passing some place that's selling similar products as hemp derived. So 2 slides to put this in perspective. The first is the map. The darkest green is full adult use, and we have 24 states now that have full adult use legalized. We have 40 states that have medical cannabis programs. Those are the middle green. And we have several states that allow low THC, high CBD products. THC is the molecule that's intoxicating. And CBD is, there's an argument as to whether it can be, but it certainly is less so. We only have 3 states now that completely prohibit cannabis, although Nebraska just passed a medical cannabis law, although that is in litigation. The triangles here show states that now expressly permit hemp-derived THC products. And you'll see that, interestingly enough, there are some states that have only medical cannabis programs and sometimes limited medical cannabis programs, yet they have stores selling hemp-derived intoxicating products. And this map only shows the expressly permitted. There are several states that one could say implicitly permit the sale of those hemp products. So originally in the country, we just had medical cannabis or adult use cannabis or remaining prohibition. Hemp and the intoxicating hemp products have clouded the waters a little. Next slide, please. So this slide shows sales to consumers. So hopefully what sticks out to you is, in part, this is enormous. I mean, the sales of cannabis or hemp intoxicating products is well over $100 billion annually in the United States. Yet, more than half of it remains on the illicit market, on the sales by those who are neither fully legal medical cannabis, adult use cannabis, or hemp. And then we have, this is approximate, over $30 billion of state legal, state regulated, and state taxed cannabis. And I think, surprising to many of us, we have the sale of intoxicating hemp derived products that are catching up in scope to that. So we really have several competing different markets selling often very much the same products, although with different levels of testing, I think, which is really important. Next slide, please. And so, Kelly, a lot of times I get the question like, well, why is this so hard? I mean, just beyond the fact that now, within the last hour, we have a new Senate Majority Leader who is politically against the legalization of cannabis. But putting aside the political side, what's so difficult here?
Yeah, many things, as you see on this very busy slide, and I won't drain this slide, but there are a lot of implications for legalizing cannabis that flow from whatever the first step is. Is it legalized? Is it decriminalized? Did we reschedule it? Each one of those scenarios, there is a waterfall of implications around, how does the federal government step in to regulate? How does taxation hit? What does interstate commerce mean? And so we've had different pieces of legislation being proposed, none have been adopted, that try to crack this problem. And now we've got a new batch of legislation that's going to try to crack the final product problem at the hemp space that will probably translate over into the cannabis space. So some of the big issues are on the slide. Early days, we were looking at the first States Act, which would have said, states, you go and do what you're going to do. Legalize, don't legalize. It's not the federal government's place. And you can see from the map that Eric just showed you what happens in the gap of that. We've got a very patchwork system right now of states regulating in different ways. And that seemed like a tidy place to start, but then how does interstate commerce play into that? Is interstate commerce assumed if states, some are legal, some are not? And can states then who have a legalized program be protective of their states? Like much like New York was with its wine industry early days and tried to like block imports. Could then a state that's legalized cannabis block imports from another state? So I mean, just a whole nest of issues around interstate commerce. Taxation is a huge issue, and the level of federal regulation, which we're going to see play out on the hemp derived product legislation space. Which federal agency, first of all, is the agency of jurisdiction? And then how much federal regulation do you overlay that very complicated state map of state regulations? If you look at what happened in Canada, Canada legalized and has a very heavy federal overlay, but did so over provinces that weren't legalized. So it was much like when alcohol came out of prohibition in the US, it was on a green field. So you had no regulations, now you have federal. Here, we've got 50 states of regulations. And so does the government come in heavy and preempt those state regulations, or do a lighter touch? And we'll walk through some of the hemp derived product bills to show kind of the flavors of that. But those are some of the big issues that are being tackled. And my perspective, I did a 3.5 year secondment, I'll say, as Canopy Growth Corporation's U.S. General Counsel. And it really matters commercially how these things play out. And, are you launching products that have 50 states worth of labels? Do you need a different label for every market that you enter? Is taxation, does it stay around 80%? In like how it all plays out, what it means to your margins and what it means to the going concern of the cannabis industry. And then that ladders back to Eric's slide on showing how big the illicit market is. If the regulated market gets bogged down on all of these issues and can't commercially survive, the illicit market is only so happy to continue to take its place to serve consumers. So next slide, please. And then this is just a flyover of the stakeholders that are all involved in these issues, and there are many. The industry is trying to organize various trade associations to have one voice, to be able to interface with the government stakeholders here. And Eric, lightly touched on the politics of it all. Cannabis it polls with constituents that, depending on what polling you're looking at, like over 70% will say on the medical side, but how that flows to its more conservative leadership in Washington is changing daily. And as leadership shifts around, like how the trade groups and, how social justice approaches the various factions on both sides of the aisle change there as well. And Eric, I don't know if you want to say anything about the stakeholders.
So the only thing I want to add, Kelly, is, just as I sit and listen to watch you present that slide, I realize, how many others are not on there that could be, right? And so if you're sitting in the audience saying, well, we're affected, it's not all inclusive, and financial institutions and those in the flow of funds are very impacted by this and are major stakeholders on this and involved in those discussions as well. I think that's the only thing I'd add to that particular slide.
Great. So next slide. I think I'm going to pass it back to you with this next one.
Yeah, absolutely. So here we get to what's next. What might we see next? And I'm going to discuss only the rescheduling and then hand it to Kelly to discuss SAFER, a word on President Trump, and really some of the hemp bills and reform that we'll see, which is critical. Next slide, please. So many of you may have heard about the rescheduling process. The FDA has recommended, and the FDA sits within Health and Human Services, they have sent through a letter that recommends rescheduling what is technically defined as marijuana under the Controlled Substances Act from Schedule 1, which is limited to drugs that have no medicinal value and have specific harms, to Schedule 3, which is for drugs that have a currently accepted medical use and have risks or harms that are viewed as commensurate with the other drugs that are listed there. So our schedules, just to be clear, go from Schedule 1, which is the most strict schedule and is considered wholly illegal controlled substances, to Schedule 5, which is viewed as those substances that have medicinal value, but have the least harms or risks. And so HHS has recommended scheduling to Schedule 3. There has been already a comment period on this. Actually, we can go to the next slide. There has been a comment period on the rescheduling that has concluded, and now a hearing before an administrative law judge has been set to start on December 2nd. And we just picked the slides in this order, which is funny because Kelly actually is an attorney of record for one of the companies in that hearing. But that hearing starts December 2nd. The administrative law judge has indicated that he will set substantive hearings in January and/or February, and then a final rule on rescheduling will follow. Next slide, please. So here we get to an important point. And as mentioned at the beginning of this webinar, we need to take this brief moment to satisfy CLE requirements by delivering the following code word. And all Kansas, New York, New Jersey, and Pennsylvania licensed attorneys must type the code word cannabis, that's CANNABIS, into the Q&A section of your screen. And please make sure to hit the send button so that it registers. And that is cannabis, in case you missed it. And then we can go to the next slide. Just quickly on the impact of rescheduling, and then I'll hand it to you, Kelly, to discuss the other things that are going on. Rescheduling marijuana to Schedule 3 would not legalize the current state programs, meaning if you're in one of those 24 states that any adult can go to a local dispensary or store and buy a cannabis product, all of that would remain federally illegal because none of those participants would be DEA registered. There's an important tax implication, and it's seen throughout the industry, even in the stock prices that are depressed. Companies directly involved in the state legal programs, because cannabis is a Schedule I drug, they may not take deductions other than costs of goods sold. So they are far less profitable than a normal tax-paying citizen. And we have this question all the time: how can it be that some of these businesses are not breaking even? Look how much business they're doing. Folks say, I look and see, people are in line out the door. How can they not be making a profit? And there are various answers to that, but the most important one really is the tax treatment, the adverse tax treatment. That would be solved by rescheduling. And I think really important is that we would have an increase in scientific and medical research. The hope there is that there is an agreement now, a consensus, that cannabis has medicinal properties. And with increased research, we hopefully will unleash the medicinal powers of the plant. We'll also learn about what's beneficial and what's harmful. And there is some research coming out of some of the harms of cannabis at certain stages. And so we'll learn more about that. And I think it's really important for that rescheduling. Let me hand it to you, Kelly, for some of the additional updates of what we have coming.
Sure. Can you go to the next slide, please? So one of the lowest hanging fruits, I'd say, for legislative reform is the Safer Banking Act. It was Safe Banking. This bill would allow for financial services from our banks to really be safe harbored around their service of the cannabis industry from any aiding and abetting or anti-money laundering and all of the things that banks worry about. So it would put into law that yes, banks can service the cannabis industry. Underlying this as a public safety issue that is without traditional banking with the cannabis industry. The cannabis industry is primarily a cash operation. So for all of the billions of dollars you see flowing around in states and all of those articles that Eric referenced, that's all happening in cash. And these operators are also paying their taxes in cash. And so you've got like sacks of cash really moving around even to our government and our government workers, which creates a huge public safety risk. And so the banking issue, I'd say, has gotten the benefit of really bipartisan support. We saw in this Congress a Republican-led effort with Senator Daines coming out of the Finance Committee, getting safer banking out of the Finance Committee on the Senate side, and really locking hands with the Democratic side to get some version of this bill that would be palatable to all. There are social equity issues still with the bill. Like it doesn't, there's a real effort to not leave anyone behind. And not make rich richer, and make sure that those disparately impacted by kind of a failed war on drugs are able to benefit from this commercial opportunity. So there's still nits with the bill. We all understand that there's been negotiations done with the House, and so there is a push to get this bill done in the lame duck period. in my time in-house, I stopped banking any commercial policies on lame duck activity. But we always, keep optimistic for that. If not, I would expect safer banking to resurrect and get momentum in the next Congress. That is banking. Oh, and with banking, and Eric mentioned the stakeholders and the financial institutions being left off. There were various forms of this bill that would have safe harbored insurance industry. Insurance is another big stakeholder that we shouldn't forget, that some are still sitting on the sidelines kind of waiting to insure, and insurance in some ways makes the world go round. So there's that. And then capital markets also, there's been amendments to try to safe harbor the exchanges from listing companies, but so far none of those versions have really started to move. Next slide, please. A lot of questions, even going into the election, what happens with a Vice President Harris president versus a former President Trump presidency? Now we know. Former President Trump came out in the campaign as supportive of Florida's legalization bill and had publicly changed his tune on cannabis just generally. That should not be taken lightly and was a big shift. Former President Trump has personal aversion to cannabis, much like President Biden did. And it was his close advisors that got him to shift his policy focus to something that maybe was just for the campaign, but it could be something more long lasting as an issue that he's willing to take into his next term of presidency. So what does that mean for legalization? Everyone's still going to be looking to Congress to actually legalize. From a purely legal perspective, there are rules around what a president can and can't do to reschedule a drug that's sitting on the CSA or deschedule a drug. So what we saw with President Biden and this rescheduling effort that Eric laid out is really as far as a president can go under the rules. We'll see what that means. For President Trump and any change of administration, the rescheduling effort that's ongoing the success of that will sit with the change in agency heads, who is our next Attorney General in particular, and who's our next administrator of the DEA. So President Trump could have influence there if he wants to push rescheduling along or stop it. But I think that the optimistic view on a next term of President Trump for cannabis is one to take, because he has publicly come out in support of at least medicinal cannabis. And there's a lot of effort to make sure that his transition team is taking up the issue seriously. Also, looking at who's going to be in charge of HHS next and the FDA and how that impacts botanical drug research will also be important. RFK has been floated, Jr. has been floated around. He is certainly in favor of shaking up systems, and he is a proponent of botanical drugs, I'd say generally. And he is pro-cannabis, so we'll just have to see where that shakes out. Next slide.
Kelly, can I just say one thing here, which is the very latest we have on this is that the press had reached out to Trump's transition team for a response on cannabis policy specifically, and they were returned with the quote, "Trump will implement the promises he made on the campaign trail." So I realize that this slide is a somewhat optimistic view. It's the things that President Trump has said that are positive, and that there might be some hurdles in Congress to getting this done. But if we take him at his word and his transition team at his word, there is something to be hopeful for here. And I just wanted to add that point as well. Back to you, Kelly, and I see Charlie joined, so I'll turn to him shortly.
Hi, Charlie, and I agree with everything Eric just said. Reasons to hope. So next slide, please. Other scenarios we might see play out. The Cole memorandum, most people on the call know, but if you don't, it was a memorandum put out by the Department of Justice that really gave guardrails to how federal resources would be implemented to enforce against the state cannabis industry, listing out priorities of enforcement that it was like youth access and, you know, cannabis operations close to schools, things like that. We might see, depending on who is the next Attorney General, a revision of the Cole Memorandum that includes safe harboring of federal agencies to allow agencies to provide entitlements to those that are working in the cannabis industry. We've seen some versions around housing and the like, but we'll just have to see where that lands with the new agency heads. Well, we've got litigation pending around the Interstate Commerce Clause that's trying to get to the Supreme Court. We'll see where that goes. And then, as you know, the flyover map of the US showed, there's no shortage of state reforms on both cannabis and hemp to either on the cannabis side give some relief to the state cannabis industries pending any federal legalization or rescheduling that would give that tax relief. And then on the hemp side, regulating those products and pushing those products in certain instances into the state marijuana programs. State compacts have been a discussion point for about 5 years, where states could come together and have interstate commerce amongst themselves to alleviate supply glut. But we'll see where all of that shakes out in with the next administration. And Eric,
Hey, Kelly, before us going to the hemp landscape, which is of course really important, I have a question for you, and then I'd like to introduce Charlie again and get his opinion on a few things. Do you, to the extent that we're able to get any federal reform in cannabis, do you see that as incremental reform in the way that you described, or do you think more likely we'd get to full legalization within the next 4 years, say?
I think we're going to see incremental reform, and I don't want to shut down the possibility of legalization in 4 years. So both. I think that a rescheduling would give the tax relief, and that will be not just for the tax relief, but that removing cannabis away from heroin and LSD next to Tylenol with codeine will make conversations with more conservative leadership so much easier. I think that half the country, rescheduling, half the country is going to think we've just legalized cannabis, and potentially half of DC for a moment. And so I think those conversations become easier for more policy reform. I think safer banking becomes easier even in that instance, though it's got its own momentum. And then I would expect a refiling of, we've got 2 legalization bills on both sides of the aisle. I would expect both to be refiled and us to get somewhere on, and it's not out of the realm of possibilities that we could do that within the next 4 years. So incremental, but like going for the big prize, always going for legalization.
So thank you very much, Kelly. And Charlie, thank you for joining us. Charlie Bachtel is the CEO of Cresco Labs, which is a publicly traded cannabis company doing business in multiple states. Charlie is the original leader of the company and remains there, and is not only a CEO in the cannabis space, but has been a thought leader as well. He teaches a class at Northwestern and has been very involved in the government relations and strategy for getting cannabis reform done. So, Charlie, thank you for joining us. And really, my question for you is, from your perspective, from your perch where you sit, where do you see the United States at this juncture with cannabis, and what do you see the prospects for what things will look like moving forward?
Yeah, no, it's a great question, and thank you for having me here today. And at the risk of potentially being redundant, if you've already touched on some of these components, it was good for me to hear sort of the latest components that you covered. But where I'm feeling where we're at a national level as it relates to this cannabis discussion is I feel like we're in a, I'll shy out of it and I'll take the easy way out here. I feel like we're in a much better position than we've ever been before. I don't know exactly where that means that we're at, but we are definitely in a better position than we've been in before. And not only from the perspective of my perch as CEO of Cresco Labs, but also as chair of National Cannabis Roundtable and the USCC. Eric, as you said, very, very engaged and very involved in the government affairs work that's being done on cannabis for years now. And look, I think cannabis has been blessed and cursed by the swinging of the pendulum at state levels and at the federal level as to how people were thinking about cannabis and the energy behind the cannabis topic. And I think we benefited, you know, in the mid 20 teens and potentially late 20 teens by a lot of energy at the state level. Momentum was great in developing a more progressive view on a very popular issue that is cannabis reform. And we had some great state legislative initiatives that set up great framework for a very compliance-focused, regulated version of cannabis. And then I think we've also, you know, sort of seen the pros and the cons, the opportunity and the risk that comes with it. And then we realized that the real devil is in the details of how you do cannabis reform. And there too, I think cannabis is going to live in this sort of the tale of two sides of a coin in how you do cannabis reform at a federal level. Do you try and come up with a solution that can get enough votes in the Senate, honestly, votes in Congress to be able to pass on how to do cannabis legalization at a federal level? Or are you going to go the other direction and the federal government sort of takes the position that this is an issue that's better left to the states to design cannabis programs in the way that they want to manage cannabis and THC in their state? And I could tell you, I feel like the pendulum is sort of swinging from maybe the more progressive views that we've had for the last 4 years of this is how we want to do cannabis reform at a federal level. And it layers in social responsibility and it layers in criminal justice reform components to potentially, as we look forward, the pendulum is most likely swinging back potentially the other direction, which is we might have to come to the realization that there might not be a perfect answer at a federal level, and that we do defer to the states on this. And that's the extent of the federal position on cannabis, is make it so similar to alcohol, that you will be legal at a federal level as long as you're legal at a state level, whatever that means. And it'll be interesting, no doubt about it. But look, from real to finish up here, cannabis has never been in a better spot than when you have both candidates of the major parties that are running for president that are both in favor of some reform, some approach to reform for cannabis at a federal level. And you know, Eric, you've and Team Kelly also, you guys have been involved now for years in helping to develop a much more educated legislature in DC that is more equipped now to address this issue in a thoughtful and thorough way than they ever have been. So I like where we sit right now, but in where we are in the pendulum swing, I feel like as we're shifting back towards maybe a states' rights approach to this, as opposed to a cure for a lot of different ailments at a federal level that gets wrapped up in cannabis reform.
Thank you, Charlie. It certainly is interesting in that we're entering a stage of deregulation. I mean, I think that's the point of it. And suggesting, you know, high regulation in this area might be a difficult take in Washington. And just with states' rights and deregulation, your point of we're in a permissive crowd and they're going to push us back down to the states and let that develop is certainly a thought-provoking process. I have an additional question for you. which is as an opera. I mean, we've talked about hemp versus cannabis, and we've now just talked about cannabis reform and are turning to hemp reform. And I mentioned that like there's competition here. So as an operator in multiple states for state regulated and taxed cannabis, can you sort of put in perspective this competitive landscape with hemp without necessarily solving it for us? And I'm not putting you in that position today, but in terms of, you know, sort of what it means competitively to you.
Sure. And so like this is a great example of the dynamic nature of this conversation as a whole, like the subject matter as a whole, especially as it relates to how to create change, how to create some sort of reform as it relates to cannabinoids at a federal level. And I think part of this is also rooted in what we just discussed. And one of the reasons I think maybe for the audience, the rationale behind this shift maybe towards more of a state's approach to this is it's important to know, I think at this point, 40 out of the 50 states have developed what are considered meaningful cannabis-related laws. Sometimes people don't include Texas or Georgia in there, and they say 38 states have legalized, but Texas and Georgia both have legalized cannabis under certain approaches and perspectives in a medical way. But every one of those 40 states has done it differently than any of the others. There's not one state that has the exact same approach to cannabis legalization as any of the other 40. So that just tells you like how difficult it is to get a one-size-fits-all approach to this. Now, if you take that concept and you even look at it, then now we're dissecting the same cannabis plant in reality, this cannabis sativa plant, and we're creating a distinction between what can be produced or extracted from it based that is exactly the same from a chemical compound position like THC. But because it has a lower percentage of it in one plant, we're going to call that hemp. And because there's higher concentrations of it in the underlying plant, we're going to call that one cannabis or marijuana. And then we're going to treat that compound differently, depending on the source that you got it from. And it's, I'm sure you guys are touching on this in a much more thorough and articulated way. But I can tell you from my perspective, it's tough. I look at Cresco Labs as a cannabinoid-based company. I look at the advocacy and the lobbying and government relations work that I do as all part of increasing the accessibility to cannabinoids, because I believe in the societal benefits of it for a variety of reasons. And to have this distinction created by the 2018 Farm Bill, where THC from a low potency plant gets treated as potentially federally legal versus that same THC molecule itself, the molecule being illegal because it came from a plant that has a higher concentration of it, that doesn't make sense. For a variety of reasons, legal, economic, regulatory standpoint. If you have a 5 milligram THC edible, the fact that that product might be legal as long as that THC oil that you put into it came from a plant that had low potency THC versus that same 5 milligram THC edible with the THC oil coming from a plant that had a higher concentration of THC, I don't think anybody would see the logic in treating that edible differently. So from a competition standpoint, it's real. I think it's also from a pure even capitalism and regulatory standpoint too, though, where those worlds collide for me is operating on the highly regulated, compliance focused cannabis side of THC. You know, the compliance hoops, regulatory hoops, and administrative burdens, cost burdens, and licensing fees, and excise taxes that my organization in the cannabis realm is subject to, whereas somebody's producing identical products. And they're not involved in a regulated model at all, and they don't have any of the burdens from an administrative standpoint, a cost standpoint, from a taxation standpoint at a federal level, you can't have a world in which both of those things coexist. It has to be one or the other. It either THC has to be part of a regulatory framework and everybody's held to that same standard and obligations, or THC, and you'll see this from the operators, or you go the other direction and it apparently is legal at a federal level and we aren't subject to licensing requirements or regulatory requirements or taxation. You can't have both. That's unsustainable.
Thank you, Charlie. And I know that your schedule is very tight today. You were squeezed. So we at Dentons, thank you for making time to drop by and speak with us. And let's talk a little bit about hemp. Kelly, can we go to the next slide and for you to talk about what are the scenarios on the federal side with hemp, because they seem to be percolating.
They are percolating, and I would probably couch this whole section into incremental reform of cannabis too. And I'm going to quote a staffer that I've worked with on one of these bills, I won't say which, that just reminded us over and over, you know, how goeth hemp, goeth cannabis. And so they are at a position that, you know, Charlie just really like outlined, but taking a different end result to say, we do have a federally legal cousin, we've got a federally illegal cousin, and we need to start regulating these cannabinoids because we have cannabinoid product problems in the state. And so if you want federal THC caps on your hemp derived cannabinoid products, you can expect to see them on cannabis down the road from the federal government. And however the agencies are set up to regulate these cannabinoid products, expect it to mirror with cannabis down the road. So we don't know how it's going to play out. Like, I know everybody's looking into their crystal ball, but certainly as those who are working to try to get sensible regulation, to maybe try to avoid some of the problems Canada's having, we look down the road to say, okay, what will this mean if the federal government has too heavy of a hand? Can we get back to the state? So that's kind of a table set for these different pieces of hemp reform that we're looking at and the different flavors of them, which are all targeted at cannabinoid products right now. So next slide, please. So the first opportunity, not the first, but one, they're all is the hemp bill, the farm bill, excuse me, that legalized hemp in the first instance. We're looking at a new farm bill in 2025, most likely. There's been extensions applied and we should get one to get us to 2025. Looking to change the THC testing level to up it to 1%. There's been some movement for amendments that do relate to finished goods and final products, but there's all kinds of legal issues with that. We could probably spend half of this discussion talking about. The farm bill is an agricultural bill for starters. The agency of jurisdiction is the USDA that has jurisdictions over things that happen in the field. Everything out of the field that's a product that goes into interstate commerce is the FDA. So having the farm bill legislate on finished product legislation or even regulation, which is what the Miller amendment that's on the slide purports to do, which sets THC caps on final product, really goes outside of scope of jurisdiction of the agencies, and then a step back outside of the scope of the committee's jurisdiction. And committees in our two parts of Congress don't really like to cede jurisdiction to each other very easily. So that would have to happen. Energy and Commerce would have to cede this entire issue to the agricultural committees, which is probably unlikely, but we'll see how the Farm Bill plays out in 2025 in those negotiations. Next slide, please. I think is Senator Paul's bill. Everybody's been very focused on Senator Paul up until maybe this morning, now that we have a leader Thune, but certainly Senator Paul's been a hemp proponent this entire time and really wants to have a hand in the next round of legislation on hemp to alleviate farmers, which raising the the THC cap to 1% does so, but it also kind of veering into the finished goods lane. The new bill that was filed in September of this year purports to raise the THC cap to 1%, but test it at the product level and not in the field. So that is also pushing into, you know, outside of the field, and then giving some easy, very light regulation around how interstate commerce could work and how the product could move without interference in interstate commerce. So a very light federal regulatory approach. The next slide. Then we have the Wyden bill that was introduced in the early summer, I think, or end of summer in August. And this is kind of a middle of the road semi-states rights approach. It does offer a layer of federal regulation over cannabinoid products. It gives the FDA, the agency of jurisdiction, the authority to create a cannabinoid product center, which is something that the FDA has wanted. It is something that the Republican leadership does not want to fund. So there'll be tension there as far as, you know, if this can actually happen. But there's anti-preemption language built into this bill that does push most of the regulatory framework of these cannabinoid products to the states, but has some limited preemption around GMPs, labeling, packaging, and advertising, trying to alleviate that scenario that I described where you have to have different packaging and labeling for every state you move into. As a former hemp operator, I still live in that nightmare of, you know, and what the cost of goods sold looks like when you're having to do that as you move across state lines. So trying to think through that, trying to give some certainty to the industry. And this bill is certainly wants to be the one that's the cannabinoid regulation bill and sets the footprint for what cannabis regulation would look like, or marijuana regulation, I guess, as we're talking about the two cousins, would look like at some point in the future. I do think if any of these footprints with the FDA get set, whatever the footprint looks like, we're going to have to live with it for a long time. Like, we've watched Canada have, you know, their level of federal regulation, and everyone's just nibbling around the edges, trying to get it changed. So I think as an industry need to be, you know, careful about how much regulation we want. Next slide, please. And this is kind of the newest bill on the scene. It's a work in progress. There's been various versions that have been discussed. Representative Griffith has been also a champion of hemp-derived CBD. He's been a champion of hemp. This bill takes a heavier federal regulatory oversight. The current versions have THC limits and cannabinoid limits generally, so CBD limits as well. Don't know where these drafts end up being, and like I said, this one is still a work in progress, but certainly sets up the FDA to be agency of jurisdiction, and we should expect a pretty heavy FDA oversight in whatever we see as a final bill. But work in progress and good work done. And next slide. So those are the flavors that we're looking at for the federal reform, kind of a light, medium, heavy, and we'll just have to see as we move into 2025 how these take shape. And in the meantime, as I say, in the gap, we saw Eric's heat map slide. The states are moving at rapid pace. Certain states and key markets like California, they do not like the hemp-derived products being either in competition with the regulated cannabis industry, that it really wants to survive and combat the illicit market, and does not like youth access to hemp-derived intoxicating products. Because back to the beginning of my slides, as we split as between the two cousins, the federally legal cousin gets the benefit of non-restricted retail, and interstate commerce. So while Charlie's compliance involves a restricted dispensary model, these hemp-derived products do not. It can be sold in gas stations and CBD shops and wine shops and all over the place. And so states want to shut that down for various reasons. And our governors are getting active. California's governor implemented emergency regulations to push all hemp-derived intoxicating products, essentially with scant levels of THC, into the dispensary model. So that's what California is looking at. Other states are also pushing into the dispensary model. Illinois has a new bill that was just filed or was filed in the prior session, and we're expecting to be filed again. That would do the same. Ohio also, and really it stems from leadership that sees a synthetic hemp-derived product problem and youth access, and then the hemp-derived Delta-9 products being competitive with, their state-regulated markets that they have a real incentive to protect. There's also advocacy within those states to protect the CBD products. So from the CBD industry's perspective, and I'm going to just use their words, these are not mine. The CBD industry is what got hemp-derived products legalized in the first place, and now they're being thrown out with the bathwater as the Delta-8 and the Delta-9 intoxicating products are taking over markets. And so some states like Colorado and Virginia have done carve-outs to allow ratioed products that allow CBD products with naturally occurring levels of THC to stay in market. And so we're seeing that model being adopted, and I would expect advocacy in these states with new bills. Ultimately, I think where the hemp industry is landing is that a state model bill is needed, especially if we have sort of a states' rights approach to the hemp cannabinoid products. But we'll see where that lands. That will all be work to be done in 2025 as well. And next slide. I think that's.
Yeah, Kelly, I think that brings us to our last slide. I'll let you bring it home in the last few minutes. I just want to note we got 2 and now I think 3 questions. And we probably won't have time, and they're really not answerable on a call like this. So I would encourage you to reach out to Kelly or me on those particular ones. And go ahead, Kelly.
Sure. I'll touch on employment issues. I know we did banking and IP, and insurance earlier, and then Eric, you can jump in on any ones that you want to add. But for employment, implications really on the federal side revolve around rescheduling. Right now, the American Disabilities Act does not cover treating any disabilities with cannabis because there's really no federally legal cannabis product to treat those disabilities. If we get to a Schedule 3, it would open up a new lane for cannabis-derived product development at a Schedule 3 pharmaceutical level, or potentially regulations that flow with that rescheduling that would allow some sort of medical use of cannabis to treat disabilities. So that could have impacts on the ADA. And in the gap, as with everything else, the states are enacting their own laws to protect both the cannabis industry and consumers, having laws that prohibit cannabis testing or prohibit prohibitions of cannabis use outside of work, things like that would discriminate against their employees that use cannabis medicinally, at least. And Eric, I don't know if you want to jump in on any of these other.
Yeah, sure. Just quickly, thank you, Kelly. And Lauren, I saw your question as well, and we're happy to answer it in more detail. But normally the laws preserve an employer's right to prevent anyone who is impaired by cannabis or anything from operating machinery. And there are tests for that. There's sobriety checks. The tests that are traditionally used, like hair and blood, are often inaccurate, and there is some development of new testing for that is not here yet, but around the corner. And so, Kelly, the only other thing I wanted to say is we described the cannabis space, we described the hemp space, we're touching here on all the areas that are affected, and particularly on the state level, the legal environment is very dynamic. We're seeing states ongoing debating cannabis laws, ongoing debating and changing hemp laws. And so the effect on your business and your employees, it's ongoing. It's really changing. So it's something that we spend our time monitoring. So unfortunately, we're out of time. I really thank you, Kelly, and Charlie. Thank you very much for joining. Really appreciate it. And thank you all for participating in today's CLE webinar. And so just as a logistic housekeeping point, in approximately 30 business days, you'll receive an email with a link to your CLE certificate. And your webinar login details will be used to process those certificates. There are no additional steps that you need to take. And just as a reminder, the code word requirement is only if you are seeking credit in Kansas, New York, New Jersey, or Pennsylvania. And with that, I thank you all very much, and I hope you have a great day.
Thank you.
Thanks.